Welcome to Rapid Fire Wednesday, Q&A for immigration professionals. I'm Kimberley Robidoux, a partner in WR Immigration San Diego office, and I am here today with Miki Matrician, who is our co-managing partner of the Boston office. Hey to you, Miki. Good to see you.
Hey, Kimberly. So for today's installment of our Rapid Fire Wednesdays, we wanted to cover outstanding researcher and extraordinary ability as a couple of other ways, in addition to the national interest waivers, to avoid the perm process. So just to provide a little background for these visa categories for everyone, like we talked about in our previous episode, the perm labor certification is the first step in a 3-part green card process. And it can be pretty expensive and labor intensive and time intensive as well for employers. And also, the other factor is that the government processing times at the Department of Labor, which is the agency that's responsible for adjudicating the perm labor certification application, has gotten longer and longer. And so those are some factors that have led many employers to pursue the national interest waiver category as an alternative to perm. And so, Kimberly, would you say that those same factors also translate to determining whether or not to pursue the outstanding researcher or extraordinary ability cases?
Yes, definitely, Miki. But there are other factors too that we discuss with our HR and global mobility partners. For instance, the categories that we're discussing today fall under the EB1, which is employment-based first preference category. And that also, means that usually there are no quota backlogs for this EB1 category. And while there is a quota backlog at this time for individuals born in India and mainland China, it is not nearly as backlogged as EB2 and EB3, right? And PERM and NIW fall under EB2. So let's first take a look at the outstanding researcher category. And for this category, the sponsoring employer, and there must be a sponsoring employer for this category, is required to show that it is a university, an institution of higher education, or a department or institute of a private employer, and that it employs at least 3 full-time persons in research activities. And, there's another and, the organization has documented accomplishments in an academic field.
Yeah, so that's a really good point that the sponsoring employer for outstanding researcher case has to also meet very specific requirements that are not applicable for perm or national interest waiver cases.
Yeah, so we can easily see how the requirement to have at least 3 persons employed full-time in research activities can be met by a university or an institution of higher education. But what necessarily does that look like for a private employer, Miki?
Yeah. So for a private employer, we talk with our HR and global mobility professionals whether or not there's any research and or development going on at the organization. And if so, how many employees are devoted to that full time? So, for example, if we're working with a civil engineering firm and let's say they're working on projects for their clients, they could potentially have employees that are researching and developing the latest technologies or processes for various roadways, right? So it might take a little bit of creativity and discussion to kind of figure out that information, find out that info. And then we need to look and see if the company can document those achievements either via like patents that they have obtained, or maybe they have gotten awards or recognition in their industry.
Okay. So, Miki, once you had the discussion and done the deep dive with your global mobility partners to get that overall viewpoint and have now determined that, the organization meets those requirements to move forward with outstanding research or case, what criteria does the foreign national employee have to meet, right? Because we have both sides of the equation here too.
Yeah, so this is really, in essence, a multi-part process. And first, the individual has to show that they have at least 3 years of experience in teaching or research in an academic field in which they'll be engaged.
So, Miki, I'm guessing that there's more to just having a 3 years of experience required by the foreign national. So what else is necessary for that foreign national to meet the outstanding researcher category?
Yeah, so this next part is typically the more difficult part, especially because USCIS interjects subjectivity into their adjudication and assessment. So We discuss with the foreign national and our global mobility partners whether or not the individual will be able to show that they have at least two out of six regulatory criteria.
Okay, so what comes next is I'm going to ask, what are those six criteria that, you're going to evaluate when you're discussing this with a foreign employee?
Yes. So happy to go over these. And I'll talk about it more in kind of general terms as opposed to specifics because, otherwise we'd be here all day talking about the criteria. So the foreign national has to show at least two of the following. So, number one, receipt of major prizes or awards for outstanding achievement in the field. Number two, membership in associations in the field that require outstanding achievements of their members. And number three, published material and professional publications written by others about the individual's work in that field. Number four, the individual's participation either individually or on a panel as the judge of the work of others in the same or similar, allied field. Number five, the individual's original scientific or scholarly research contributions to the academic field. And then number six, the individual's authorship of scholarly articles, preferably in scholarly journals with international circulation in that same field.
So we understand that some people can be researchers, maybe not in the traditional sense. So in that capacity, if their achievements don't fit neatly into these six categories, is there any advice that you can provide to HR and global mobility professionals that might be helpful to kind of fit them into this category?
Yeah, there is some flexibility. So there is, basically a catch-all criteria that's called comparable evidence, which basically just means that if the standards don't readily apply, we can use any comparable evidence to establish the eligibility.
Right. Now, Miki, you mentioned that there is some subjectivity to this outstanding researcher category. So if the employer proves that they meet the employer requirements, and then the individual possesses at least two of these regulatory criteria, does that mean that they're going to be approved for an outstanding researcher?
Yeah, so not exactly. It's not just a matter of just kind of checking off the boxes and saying like, yep, done that, done that. It's really that USCIS then conducts a final merits determination, which means that they're going to review the evidence in its totality to determine if the employer met, by a preponderance of the evidence legal standard, whether the individual and the employer have met the criteria and that the individual is recognized internationally as being outstanding in that specific area.
So there allows us to be a little creative in preparing these cases for immigration and kind of pleading our case, right? Telling the story to them. So while we're on the topic of outstanding researcher, right, we also thought that we would talk about extraordinary ability as an employment-based first preference category because they're somewhat similar. They're both in EB1, but they also have some criteria that are similar. And so off the bat, one thing to think about is that this category of extraordinary ability does not require that the employer qualify as well, right? So we can take the employer kind of sort of out of the equation, but then some of the criteria that the foreign national employee needs to meet is also similar to outstanding researcher. But in this category, the individual has to meet at least 3 out of 10 criteria, or they have to provide evidence of a one-time achievement, such as a Pulitzer Prize or an Oscar, or, it's July, the Olympics are coming up in Paris, so they can show an Olympic gold medal. And how amazing would that be to just be like, boom, here's, I meet this extraordinary ability by one piece of evidence. So a lot of people don't fit into that particular achievement because those are the top. But we have many others who are truly skilled in their area of expertise. So what is the evidence that an individual have to show with respect to the criteria, as well as also showing that they are going to continue to work in their area of expertise?
Yeah.
So there's a criteria, and I just want to sneak this in here. There's no labor cert that's required, right? So that's also a major benefit of this category.
Exactly. So, I think, immigration lawyers consider the extraordinary ability to be the toughest to get. So tougher than NIW in some ways, tougher than outstanding researcher. I think it is the most heavily scrutinized. So there are a few more ways to meet the requirements, because there are 10 possible categories of evidence and you need to meet three. So here we go. So, evidence of receipt of a lesser national or internationally recognized prize or awards, membership in associations in the field that demand outstanding achievement of their members, published material about the individual in professional or major trade publications or other major media, evidence that the individual has been asked to judge the work of others, either as an individual or on a panel, and evidence of the individual's original scientific, scholarly, artistic, athletic, or business related contributions of major significance to the field, evidence of the individual's authorship of scholarly articles in professional or major trade publications, evidence that the individual's work has been displayed at artistic exhibitions or showcases. If it's a, performance-based individual, then the individual's performance of a leading or role, or, in a typical employment-based case, a leading or critical role in distinguished organizations, evidence that the individual commands a high salary in comparison with others in the field, and then evidence of commercial success in the performing arts. So those are the 10. I think it's important to highlight here that this category is open to individuals in almost any field, any industry, and not just limited to experts in an academic field. And so it is quite flexible in terms of the areas of focus and area of endeavor, although it is a tougher threshold to meet.
Okay. So, Miki, how do you suggest that HR and global mobility team members go about determining whether or not to pursue outstanding researcher or extraordinary ability category for a specific employee?
Yeah, I think it's important really to communicate that not everyone is going to be eligible for either of those categories. And, it also depends on the company or organization. And the company might not even meet the initial company requirements for outstanding researcher that we talked about. So it's going to naturally be a small percentage of people that would qualify for either of these categories. And I think it's also important that, you're setting the expectations with your foreign national population. So if, HR is wanting to include this in the immigration policy, I would recommend that they make it clear that sponsorship of one of these categories is really going to be at the sole discretion of HR or global mobility based upon an evaluation of really all of the facts of the case and partnering with legal counsel. And then I would also recommend that human resources or global mobility work with legal counsel to come up with some parameters for who should be evaluated for either of these categories. For example, based upon a review of the population, maybe certain roles or certain business units might make the most sense to be vetted for these categories. And then other criteria, like, for example, if you're working for a biotech company, maybe you would focus on certain type of research-based roles. And then you might also set a threshold like, carving out people who have done certain things, like have published 3 papers or something like that. And obviously that's going to vary depending on the type of company and what industry this is. And so it really is best for HR to partner up with counsel to figure all of this out. It's all about selecting situations that qualify for any of these categories and figure out what's more likely than not to be approved. So we addressed a question last episode about another achievement-based green card process, the national interest waivers that we've been talking about. And it's relevant to our conversation today as well. And essentially, as a follow up question from our previous session in June on the presidential election, the question is, should HR and global mobility professionals be more conservative when they're considering outstanding researcher or extraordinary ability qualifications given the presidential elections coming up in November?
That is a good question. And it also, falls into the situation with extraordinary ability and outstanding researcher categories. Because these have a level of subjectivity, we do, recommend that if an organization is considering sponsoring an individual under one of these EB1 categories, that it is something to do a review now, right? It can take a few months to prepare the cases and then several weeks to have them adjudicated by the immigration service. So it is something that, yeah, I mean, we're talking with our clients and discussing the fact that, this presidential election, if there is a change in administration, more likely than not, we could see a tightening of, the approvals, so to speak, of these categories. So it might be something that organizations should definitely consider before the election. Some of the other things to think about too is, given the lengthy quota backlog for certain individuals, especially those born in mainland China or India, there might be some benefits, right, to HR and global mobility professionals to consider when assessing the EB1 compared to a perm-based or NIW-based EB2 case, right? There's timing with quota backlogs, there's timing with the election, but there are some other things to consider as well.
Yeah, that I totally agree. That's definitely something that companies should be considering. And the EB1 backlog is really not as bad right now as it could be for people who were born in a backlog country, for example, India or mainland China. So much better than having to deter career growth within the company. For example, with the perm that we've discussed in the past, that the process is so tied to the position. And so people may be deterred from progressing in their career, but that's really less of the case here for the outstanding researcher or extraordinary ability cases. And the other benefit that we've been talking about, the whole basis for this is that the case would not have to go through the Department of Labor, which is so backlogged. So it potentially can save lots of time as well as money for employers.
Yeah, it's a good point as well. One of the other things that we had briefly discussed is, and we had mentioned, like the extraordinary ability can also be a self-petition case, right? So there's potentially some benefits to that. But, when discussing how to proceed, a lot of times, talking with HR and the individual, especially if that individual is doing something that is significantly benefiting the organization, it might be best to have the organization file as the petitioner and proceed that way as opposed to a self-petition. But there's all kinds of ways to be strategic in assessing, how to proceed with this particular category. One of the other things that you and I were looking at, Miki, is just like with NIW, right? We were looking at the USCIS statistics that, and, we were kind of surprised, but not so much given this current administration. But there is some support in those statistics that the EB1 might be a good option if an individual qualifies. Can you provide a little bit more information on that?
Yes, yeah, happy to provide the numbers. So for fiscal year 2022, the approval rate for EB1A, the extraordinary ability, was 53.6%, which basically is 5,000 and some approved out of about 10,000 petitions. And then the EB1B, outstanding researcher category, was at 86.6%, which I thought was amazing. So about 3,700 approved out of about 4,300. So that's pretty good odds. And then in fiscal year 2023, the overall approval rate was 65.1%. And the number of petitions filed in 2023 went up to 15,000, almost 16,000. And then the outstanding researcher category approval rate was at 91.3%, with about 5,500 cases received. So, yeah, I mean, those numbers are promising. And as Kimberly mentioned, it now is probably a really great time to take a look at eligibility for potential qualified individuals before a potential change in administration, if that happens that way. So that's a wrap for us for today. Join us next week for discussion about international travel, supporting foreign nationals coming back into the United States.
Yep. And if you don't already, please follow us on our LinkedIn with WR Immigration, as well as our individual profiles. And we also transcribe the Rapid Fire Wednesdays to a post that we do weekly as a newsletter. And you can subscribe to that. The link to subscribe will be in the comments. So until next week, have a wonderful one. Take care.
Thanks, Kim.